mechanism provided in the basic law. And you remember which provision is that? Which sets the interpretation mechanism in the basic law. Do you remember? Which article is that in the basic law, the Hong Kong basic law? Anybody? That's correct. Article 158. And this is in terms of a structure, in terms of the normal structure in a written law in Hong Kong, i.e. in an ordinance. We do not actually need to have such a provision. Why is that? Why is that we don't need to have a provision to say who actually has the authority to interpret a certain a particular piece of legislation? Why is that so? We don't need one. Why is that? Why do we not need a provision to say who has the authority to interpret a certain piece of a certain ordinance or a certain regulation? So who makes the law in Hong Kong then? Because under common law system, the court interpret the law. So yes, that's correct. And Jia Yi, do you agree? Do you agree with what Wang Jiho had put down? Yes, because you put it down as a question mark. I'm not quite sure what did you mean, when you put it down as a question mark. Right. Now, and of course, it follows, the next question that follows from your answer, your response, of course, is whether the basic law is a law made under the common law system. Is it or is it not? Is it a common law system legislation? Well, this is exactly the slide that why I'm showing this slide to you. The fact that we always have to remember one country, two systems, and under that, the two systems are respectively the system being practiced on the mainland of People's Republic of China, and the other is the common law system being practiced, or first of all being maintained under Article 8 of the Basic Law and being practiced at the same practiced in Hong Kong. And under that system, as Wang Jiho said, the courts are given the power to interpret the law. And because Article 19, Article 8 for the matter, maintains that power, so there is no need for a provision to be made in explicit terms in an ordinance as to who interpret an ordinance. It is, of course, the law. I mean, at the court. And but in the case of the Hong Kong Basic Law, it is a piece of national law made by the National People's Congress. And under the PRC Constitution, Article 67, it has already been provided that the Standing Committee has the power and function to interpret law. But it was considered necessary in the case of Hong Kong Basic Law that power, that Standing Committee's power to interpret the law, should be reflected in the Basic Law, because for the simple reason that under the one country, two systems, and in accordance with Article 12 of the Basic Law, under which Hong Kong enjoys a high degree of autonomy, and that high degree of autonomy includes, in accordance with Article 2, executive, legislative, and independent judicial power. That judicial power necessarily includes the power to interpret the law in the process during the course of adjudication. And under the overall scheme of the Basic Law, the power to interpret the Basic Law is given to courts in Hong Kong by way of authorization. And this authorization is with limitations, with qualifications. What is that? What are those? Do you remember? What are those qualifications to the power to interpret the Basic Law? What are the limitations? Do you remember? If you don't, you can turn to Article 158, and you see it set out in in clear terms. Excuse me. What is the limitation? Exactly, yes. Within the limit of the autonomy of the region. It does not say which articles. It says it is the provisions of the basic law which are within the limits of the autonomy of the region. Since it's not provided in explicit terms, there may very well be cases or situations where there's a little bit of gray area. But so far, by and large, we haven't come across any challenge that a court in Hong Kong had exceeded their authority to interpret the law, which is outside the autonomy or outside the limit of autonomy of the region. Except perhaps in Galing, when the court decided that there was no need, there was the provisions that were subject to the interpretation did not fall outside of the autonomy of the region. Now, with that as the introduction tonight, it explains this big question mark that we put on the slide here. The slide is in the form of a question. The question being, which system in Hong Kong is being practiced? Which system of interpretation that we do practice in Hong Kong basic law? Well, under one country, two systems, Hong Kong follows the common law system, isn't it? Article 8. But Hong Kong basic law itself is a national law made under the Chinese legal system. So conceptually, you will see actually there is a clash, and in order to resolve this clash, there is what we call a compromise mechanism is provided. And the result being that what we have now is a system, or rather the basic law, Hong Kong basic law, is subject to both systems of interpretation. Well, just superficially, one can imagine, because they are of two different systems, then theoretically or conceptually, conflicts are bound to exist. Although one may argue that despite the interpretation being undertaken in the two different systems, because of their fundamental principles, which in a lot of sense are very similar. On the one hand, Hong Kong, now we have seen the judgments made by the Court of Final Appeal that we should adopt the purposive approach, and which is indeed for the courts to give effect as far as possible to the legislative intent behind the enactment of the provision. This approach, purposive approach, sometimes we call contextual approach, because in applying that, we should also construe or interpret provisions in their proper context. On the mainland legal system, interpretation is a tool to give effect to the original intention of the legislature. So just on the face of it, they are pretty similar. And in Hong Kong, we have now, since 1997, we have seen so far 5 incidences of interpretation. We will go. In fact, I had mentioned this previously, that for this evening we will pick. We'll look at them, and then at the same time, maybe subject to what your interest, we may look more closely, 1 or 2 more closely. Just going back, not going back, but just focusing on, or rather, trying to be more specific now. We just been sort of talking at a sort of conceptual level. More specifically, we see that in Article 158, this is how it's provided. Just quoted you the wording. This is a photo that you may see, very often see now on the news when the Standing Committee meets. Standing Committee of the National People's Congress is much smaller body compared to the plenary body, the National People's Congress, of which we are talking about thousands, 3,000 something members, whereas for Standing Committee there are 170 something, less than 200. So 158.1 is where the Hong Kong Basic Law set out in very simple terms, but clear, the power vests in the National People's Congress Standing Committee. 158.2 on the face of it, just logically, just looking at the language, the NPC Standing Committee authorizes the courts of Hong Kong SAR to interpret the Basic Law. First, this applies to all the courts in Hong Kong, from the most junior courts to the most senior courts, the basic courts, and up to the Court of Final Appeal. Secondly, this authorization is what actually is expected or was expected by the drafters when they authorize the Hong Kong courts to interpret a Chinese national law. What do they expect? Do they expect them to apply common law principles, or mainland principles, or a special kind of principle which is a fusion of these two separate principles from these separate systems? It doesn't say, does it? It doesn't say. And it had been left as something to be elaborated or considered. It became a point of contention when before the Court of Appeal, in the case of Lao Guangyong, in the case of Lao Guangyong, and also Zhong Fengyun. Secondly, as I had said to you, 158 did not use the skill of by identifying the specific provisions in the Basic Law that may be interpreted by the Hong Kong courts. It uses an expression or the approach of setting out a principle, and the principle being which are within the limits of the autonomy of the region. This itself, ironically, requires interpretation. Each case will have to be looked at individually, and then it will be a matter for, in the case of Hong Kong, a matter for the courts to decide what that means. And outside of this provision, just imagine, in practice, it also sometimes gives rise to complications. In the common law system, there is the doctrine of precedence. Whatever interpretation a lower court has given to a particular provision in the Basic Law is not final, because that interpretation may not bind future courts because of the status of the court that made the interpretation. That itself may not be satisfactory, especially if the interpretation made by a lower court is not subject to appeal. No appeal happened. No, the parties did not take the case to a higher court or to the top court. Then that interpretation given by a basic court, a junior court, may become the only reference that people can rely on when trying to understand, when wanting to find out the exact meaning or the legal effect of a certain basic law provision. And also, but this is unsatisfactory because that the interpretation is not binding. It's not binding. It cannot be binding. It's the basic court, and so that is a situation where it becomes, it might become unsatisfactory. Of course, there is a mechanism to correct that. The mechanism is if the case is taken to a higher court by way of appeal or review, or if there was no such review, no such appeal, and if it was considered to be so important that it must be put right, corrected, in theory, the Standing Committee of the National People's Congress can come out and put or deliver an interpretation to correct that. So far, we haven't come across such need, and but what I was saying to you was a possibility in theory. This kind of arrangement, of course, is not unique to Hong Kong, but is quite similar to the system in practice in the European Union, which has basically practices a continental law. The next slide again raises or shows one question that people used to have on the interpretation system, and asked whether it is the Chinese system that should come first. Well, Article 158 is not entirely clear for reasons that I just explained. It's sort of it's not a step-by-step scenario. Even with Article 158(3), that arrangement only applies to a case that is before the Court of Final Appeal, and if the decision turns on the interpretation of a particular basic law provision, only then the court is obliged to submit the relevant provisions to the Standing Committee for an interpretation. And it is after such interpretation is made, then the Court of Final Appeal will have to follow whatever interpretation is given. In the case of Lau Guangyong and Zhang Fengyun, Court of Final Appeal accepted that Standing Committee has general and unqualified power to interpret any part of Hong Kong basic law. It is not just the provisions that fall within the description of provisions that regulate the central authority and relationship between central authorities and Hong Kong Special Administrative Region, or concerns matters that come within the responsibility of the central authorities under the basic law. It's unqualified. There are no conditions, and indeed, it's a power because it's general, no precondition. An interpretation can happen both before, during, and after a court case. Also, Standing Committee does not need to be asked before it interprets the basic law. It can indeed take its own initiative to interpret whichever part of the basic law they thought necessary should be interpreted. As I said, this is the only correct way of understanding the mechanism of interpretation. as provided by the Hong Kong Basic Law. And when the Standing Committee decided to exercise that power, it is also up to the Standing Committee to decide how an interpretation should be made and on what principle that interpretation should rely. But whatever that process may take, whatever that result or whatever interpretation it is given, under Article 158, courts must follow the interpretation of the Standing Committee. And this is a very interesting scenario, especially where if it was provisions that actually come within the limit of autonomy of the region. What about those though? What about those? Now, I have said 1582 is a matter of authorization, but in relation to provisions which are within the limits of autonomy of the region. But what if they are outside? Do they ever have the power to interpret? It's not quite clear. But the opening sentence of 1583 is this: the courts of Hong Kong Special Administrative Region, this is talking about courts at all levels, may also interpret other provisions of this law in adjudicating cases. So this other provision must be provisions other than those within the limits of the autonomy of the region. And in 1583, it goes on to make certain provisions setting out how and when CFA has to refer the provisions to or seek interpretation of certain provisions by the Standing Committee. The last sentence the second last sentence, last two sentences says this. This is 1583. When the Standing Committee makes an interpretation of the provisions concerned, the courts of the region, in applying those provisions, shall follow the interpretation of the Standing Committee. However, judgments previously rendered shall not be affected. Now that is also very much a compromise, because in strict legal terms, an interpretation given by the Standing Committee should have effect from the first day when the Basic Law began functioning. So 1st of July 1997. However, 1583, the last sentence does make it clear that such interpretation does not affect actual decisions in previous court cases. So if a court had already made a decision, and if that decision turned out to be advantageous to the applicant, a subsequent interpretation, even if it did not accord with the previous decision of the court, the previous decision shall not be affected. This is, of course, in the interest of clarity and also finality. But the practical effect is something which we have to be very clear in our mind. Any part of the decisions which is contrary to a standing committee's interpretation cannot be used as precedents in future court cases. So that is important for certainty, and it is, to be quite honest, it is something which one would expect, to be in the law. Otherwise, there will be a lot of confusion. Any questions so far? As I said, there aren't that many interpretations. So, well, I would suggest we do not, when we're looking at the question of interpretation, it is actually a system of its own, which is unrelated to appeal, unrelated to review, under the procedures in Hong Kong, under existing law, under common law. So the question here is, before involving NPSC for interpretation, is case stated from DOJ also a way of review? No, it isn't. Neither is that considered as an appeal. They are separate systems. They don't have that relationship. And under Article 8, the common law itself, of course, include decisions of court. And if that decision, being part of the common law, was found to be in contravention with the basic law, that decision, or rather the principles are developed or disclosed by that decision, the principle of law, I mean, will not take effect if there was a basic law interpretation which is contrary to what was decided. All right. So this is where it may appear to be confusing. Fortunately, since 1997, most of the cases are decided by the courts, and very few turn on interpretation by the standing committee. The general approach in Hong Kong is to continue applying the law under the mechanism that we are familiar with. The mechanism of interpretation is not meant to undermine the integrity of the existing common law system, but constitutionally is something that has to find a place, has to be given a place in the system. The few bullet points here, you will see the standing committee's decision. How do we use it? It's still we'll come back to this because it's difficult to talk about to explain in a bit of a vacuum. But the principles are quite clear, right? If the Standing Committee had already given an interpretation to certain provisions in the Basic Law, then that interpretation by the Standing Committee becomes part of the law, and the Hong Kong courts will have to follow. So far, very few. I mean, I don't. The one that is that reflects these principles more clearly is in Garling. If there's no standing committee interpretation, do not need to ask for one, except in rare circumstances listed in 1583. So I think this has been the approach, and until when the electrical oath cases came on stream. So that's the scheme, the Basic Law scheme, which of course is a PRC scheme. What about in practice? How is it going to work? Well, the most relevant case would be the case of Zhong Fengyun. The courts had already said in 1999 in Garling's case, purposive approach. And the Court of Final Appeal, of course, understand and accepted one country, two systems. So the interface between Hong Kong SAR courts, Hong Kong SAR government, and then the Standing Committee in the context of interpretation is clear in relation to certain aspects, but sometimes not that clear in other aspects of this interpretation mechanism. The courts in Hong Kong, of course, if there were binding decisions that are binding, then they will follow whatever is in that decision, and even if that decision, or including decisions on the interpretation of the Basic Law provisions, you just follow them. Yeah? So we say, and Zhong Fengyun also make it very clear, the court will apply purposive approach under the common law system to interpret the Basic Law. So let's see how in practical terms, what does that mean? Well, if the provision concerns certain human rights, or we say fundamental rights, such as the right to go to school, the right to go to hospitals, the right to do this and to do that. So as long as these sort of rights, personal right, right to, for example, your face, these or right to take part in public life, so on. Hong Kong Basic Law, there's a long list. And the Court of Final Appeal in Garling said we need to apply a generous approach because these are the constitutional guarantees for the freedoms that lie at the heart of Hong Kong's separate system. When we look at the Basic Law and also the Hong Kong Bill of Rights Ordinance, you'll find that some, in fact most of them, are conditional, i.e. you have to do certain thing, make sure certain thing happen before you can invite the judges to interpret an ordinance. In Garling, Court of Final Appeal said we need to apply the generous approach because the Basic Law gives us constitutional guarantees for freedoms that lie at the heart of Hong Kong's legal system. This is a general description, and just from experience, from what had taken place, for the Standing Committee to render interpretation, you will see that the Hong Kong courts generally applies what we call generous approach, means in favor of giving protection to fundamental rights. When you get to this point, you can always, or you should actually turn to the relevant articles in the Basic Law, and of course you can find them in the chapter 3. And at the same time, you should have beside you the Hong Kong Bill of Rights Ordinance, and you can see how these provisions are drafted. And in the Basic Law, you will find the expression in accordance with law set out at many places where rights are to be protected. And what is law? In human rights law, as we had discussed earlier under chapter 8, they have these laws have to satisfy certain criteria before they are given the proper recognition and have the effect of law, i.e. the most important effect is compulsion, where anybody subject to the law will have to do it, to perform the way it's provided in the law. That is the fundamental principle. And in fact, it's just a matter of reality. There are rights invariably are subject to certain conditions when you seek to exercise those powers. As an example, Leung Kok-hong against Hong Kong SAR, the Court of Final Appeal said minority views may be disagreeable, may be unpopular, distasteful, or even offensive to others, but tolerance is a hallmark of a pluralistic society. So there's generally, in the context of non-discrimination, the Court of Final Appeal, Hong Kong's Court of Final Appeal, seemed to be fairly liberal. The the standard that follow it follows is more follow quite closely with that, especially in the European Court of Human Rights. In any event, in the case of W against Registrar of Marriages, the facts were such that there was a couple who wanted to be married under the civil ceremony, civil procedure under marriage ordinance. That is, there's no need for them to go to a lawyer or others, but simply go to the registrar of marriages. And under the marriage ordinance, the registrar will have a duty to assist this couple to register their marriage. But on this case, the registrar said, "Well, you two are male. You cannot. Therefore, your relationship is not recognized, and I cannot do the registration for you." The case went to court, and the argument was whether a man and a woman referred to in the marriage ordinance when it says woman, includes a person who had undergone surgical operation and changed from being biologically a man to a woman. The registrar did not think so, did not agree. The case went to court and eventually Court of Final Appeal. And the Court of Final Appeal upheld the right of this transsexual, i.e. the person who had undergone surgical operation, and it was considered to be a right, a family right, and the system of not allowing that person to be registered in the marriage register would be contrary to the law. This is what the Court of Final Appeal, the effect of that is, and you can see how an interpretation may affect directly how a person exercises or enjoys certain rights provided by the Basic Law. The court went on a little bit more in the context of separation of power, more in the context of explaining how restricted or how limited a court may be invited to consider this issue without proceedings before them. The Court of Final Appeal also, in that context, was not deciding on the substantive law of marriages or inheritance, but a very narrow issue of how the marriage ordinance should be interpreted. Such interpretation must be consistent or must not contravene the Basic Law, and the Basic Law has sufficiently clear provisions in ensuring that all people are equal, and that there should be no discrimination. And those are the main principles under which the court was able to construe the relevant ordinance and to come to a decision that it do not rule out such marriage. But it did go on to say that in relation to the lawfulness of such marriage and also the implications of inheritance and so on, is a big community issue, and it should be government taking the lead in terms of consultation and also deciding whether legislation ought to be passed. to give effect to such policy. As a matter of fact, I don't think government has done anything to enact a piece of legislation. So the substantive side of this matter, the issue, is still left a little bit open. So just a little bit of repetition there. The courts can interpret parts of Hong Kong law inside of Hong Kong's autonomy on their own. But it will be different if parts of Hong Kong basic law is outside Hong Kong's autonomy. Lower courts can still interpret on their own, but when it comes to Court of Final Appeal, the Court of Final Appeal must ask Standing Committee before a final judgment is made. In the course of the last 23 years, we have only one example of the court asking Standing Committee for an interpretation under Article 1583 before a final judgment is made. The provision, the relevant part of the 1583 is reproduced on the screen. We can go through them together. It says the courts of the Hong Kong SAR may also interpret other provisions of this law in adjudicating cases. However, if the courts of the region in adjudicating cases need to interpret the provisions of this law concerning affairs which are the responsibility of the Central People's Government, or concerning the relationship between the central authorities and the region, and if such interpretation will affect the judgments on the cases, the courts of the region shall, before making their final judgments, which are not appealable, seek an interpretation of the relevant provisions from the National People's Congress Standing Committee through the Court of Final Appeal of the region. One 1583 is a fairly long provision in the Basic Law. It contains is legislating against specific scenarios. Okay. All right, let's take a break now, 15 minutes, and then we'll come back to carry on with this. In the meantime, you can go back to materials a little, even a little bit further, and because if you might have any questions, you can ask them. I do see that we will be able to have a bit of time left after I finish all the prepared material for this lesson. I may actually take you take you to looking at the national security law as a supplement to what we have set out in Chapter 7 in relation to Article 23 of the Basic Law. So since June the 30th last year, there is this law safeguarding national security, which took effect in Hong Kong SAR. All right, so I'll see you in 15 minutes time. See you again, I mean. hope I dealt with the questions. I typed it out so that is just reduce the chances of misunderstanding. We have so far one case which the Court of Final Appeal had referred to the Standing Committee for an interpretation. That is the case of Democratic Republic of Congo versus FG Hemisphere. The case involved debts originally owed by the government of the Democratic Republic of Congo to a company, actually it's a Yugoslavia company, for electricity projects which Congo government had failed to pay and which had been the subject of an arbitration award in the company's favor in London. So that company won the case against the Congo government. And as is common in the commercial world, the debt that Congo government owed was being sold or transferred to a company called Hemisphere. So the Hemisphere bought the right to the debt and went after Congo government in different countries. The case got to Hong Kong because China Railways, which is a mainland company which is listed in Hong Kong, had agreed to pay a substantial amount of money to the Congo government in relation to a mining project. So you can see, that's how China, or rather, the case involved China, because China had promised to give money to Congo government, and Hemisphere is the creditor. So the Hemisphere came to Hong Kong and tried to have some money owed to the Congo government instead used to satisfy the unpaid debts, i.e. to ask the Hong Kong courts to order the Chinese government to pay the money to Hemisphere instead of paying to Congo government, because Congo government owe Hemisphere a debt. Well, foreign governments have always been immune from being sued over political matters in the Hong Kong courts. And before 1997, the Hong Kong courts apply a common law principle of what we call restricted immunity, which meant that foreign government could be sued over commercial matters. And in this case, it is commercial matters, and in this case, the Congo government was acting in a commercial setting. So, under the pre-97 principle that applied, the principle that applied pre-97, Congo government could be sued in Hong Kong. However, that is not the principle that apply on the mainland. This is not the law that applies, that China applies. China applied the principle of absolute immunity. So if the party to litigation was acting in the capacity of a government, then under the absolute immunity principle, the government cannot be sued. So because of this, the case went before the Court of Final Appeal, and the most important issue was which of the sovereign immunity rule should apply. Should it be the pre-97 rule, which is a restrictive immunity rule, or after 97 it should be PRC's rule? And this involves an interpretation of Article 13 and Article 19 of the Basic Law. The case was heard by 5 judges at the Court of Final Appeal, and there was a division of opinion. 3 considered that the matter involved or triggered Article 1583 and in relation to the particular question, i.e. which principle of immunity to apply, as it is should it be restrictive immunity or absolute immunity, it falls within the realm of foreign affairs, which is outside of the autonomy of Hong Kong, SAR, and therefore must refer to the Court of the Standing Committee for interpretation. 2 of them did not think so, and the court actually, in the course of the litigation of the hearing, also got hold of produced as evidence various memorandum issued by the Ministry of Foreign Affairs of China. Now they actually, the way they did it, the way that they referred the case to Standing Committee was they wrote a long 265-page so-called Provisional Judgement. They came to a decision actually, but they didn't describe it as their decision, but only describing it as provisional for the Standing Committee, hoping that the Standing Committee will endorse what the majority thought. In fact, they actually, by their own analysis, came to the view that because China is a unitary state and Hong Kong being part of China, in terms of the applicable applicable principle in the realm of, in the area of foreign affairs, there should only be one rule, and that rule must be the rule applied by mainland China. So the matter went to Standing Committee, and the Standing Committee issued an interpretation on Article 13(1) and Article 19 on August 26, 2011. And the decision became very, in a way, straightforward. The Standing Committee confirmed that if the majority decision was correct, and the Hong Kong courts must follow the same practice as mainland courts on this matter. And as a result, Hemisphere lost its case against the Congo government over the unpaid debts, and then it became a rule, a general rule that foreign governments cannot be sued in the Hong Kong courts. Subject to certain exceptions, and if there was a clear waiver, then they might be able to be sued. The result, I think, as far as the minority, the two other judges who did not agree with the transfer of with the submission of the case for interpretation, held the view that the case did not involve the need to interpret the basic law. Simply based on the common law principles, they would arrive at the same conclusion. They will arrive at the same conclusion. The case itself, of course, has brought some ramifications over some ramifications over the confidence of entering into commercial dealings with government or governmental organizations subject to Hong Kong law, because it had been for some people, they had thought the pre-97 restrictive immunity rule should apply, and therefore as long as the transaction is clearly commercial, then whether the other party to the transaction is or is not a government, is or is not government or governmental agency, it doesn't matter. But now with with the Standing Committee interpretation and also the Court of Final Appeals decision, that has changed. That's different from what people generally had thought. And indeed, since the Congo case, it was said that people had doubts, or less. They felt less willing to have their cases heard in Hong Kong, even arbitration cases, and therefore when they enter into contracts, we're talking about international contracts or contracts involving international parties, if they were to make a choice on the applicable law, they might be less willing to choose Hong Kong law because of this difference. And also because of this case, some have thought that it also led people to suspect that the courts in Hong Kong are not as independent as they had thought, i.e. Hong Kong courts, they are subject to the decisions of the Standing Committee of the National People's Congress, i.e. subject to means they have to follow their decision. But of course, conceptually or in theory, that is not the case, because the Standing Committee does not decide on the result of a particular case. The Standing Committee's role is to interpret the law, and it is for the court to apply the law. And indeed, if you look at it more in a more proper perspective, that's always been the case in common law system as well. The lawmaking body makes the law, and it is for the court to give effect to that law. So on the face of it, it is not that different from what common law system is practicing. However, I think this is really as a result of how people understood or understand the PRC principle policy of one country, two systems. And when they come to two systems, they will expect, for some, they expect they are entirely separate. But as a matter of legal analysis, that cannot be the case, and it isn't. As a matter of legal analysis, we had gone through earlier this morning, this evening, how Article 158 has struck a compromise in order to accommodate these two systems, but with the backdrop, with the fundamental backdrop that the two systems operate within one country. So conceptually, of course, we have to look at it, more dispassionately, more objectively, and even examining when examining the very important issue of whether courts are independent in Hong Kong. So of course you can come to different conclusions based on your own analysis, but the analysis, I think the key elements that you must base on those key elements that I mentioned, and also the proper significance, the significance of those. But just like but people as learned as Mr. Justice Bukhari, who was our of course our one of our judges on the Court of Final Appeal, very respectable judge. He said, and this is often quoted, and when you go to our manual, you see the quotation given to you. It says, he said, it has always been known that the day would come when the court has to give a decision on judicial independence. That day has come. Judicial independence is not to be found in what the courts merely say. It is to be found in what the courts actually do. In other words, it is to be found in what the courts decide. Okay, so I think there's a lot of wisdom in what Mr. Justice Bukhari said, and it really lies on what the courts decide. The courts decide on this occasion not only what the proper rule, proper principle should be, but also the majority decide in accordance with the basic law, because it involves an interpretation of Article 13 and 19, the matter should go to the Standing Committee. When you look at Article 13, Article 13 on the face of it says pretty straightforward. It says the CPG, the Central People's Government, shall be responsible for the foreign affairs relating to Hong Kong Special Administrative Region. So the question then becomes whether the sovereign immunity rule is or is not a matter of foreign affairs. Well, I think the answer is fairly strict. It's quite clear. It must be. It must be. And then Article 19 says Hong Kong Special Administrative Region shall be vested with independent judicial power, including that of final adjudication. And then it goes on to say, courts shall have jurisdiction over all cases in the region, except restrictions imposed by the legal system and principles previously enforced in Hong Kong shall be maintained. So, previous system, restrictive immunity, courts will have jurisdiction. However, if it was absolute immunity, then no jurisdiction. No jurisdiction here means no power. Right? So that was what the majority decided, but that should be where the tension lies in trying to understand or make a judgment as to whether the courts are actually independent or acted independently in this case. Any questions on Congo? I saw that information note from Letco for your interest regarding Congo. Oh, let me see which one did you pick up? Yes, you right. You can take a look at it. It's very interesting paper. Yeah. Right. So I shall leave you to look at this outside external source. This paper was prepared to assist you to not you, but members of the public to understand the various views expressed on the implication of Congo's case. Do you have any questions from this? And I set out here the 5 situations, previous occasions when the Standing Committee made interpretation. We have looked at Ngarling in our last lesson, and then Ngarling took place after the court made the Court of Final Appeal had made its decision, and you will remember Ngarling is a case where the Court of Final Appeal has a very exceptional took a very exceptional measure of issuing a clarification on the judgment, and the clarification is more about defining the proper relationship between Hong Kong courts and the Standing Committee, because in the original judgment, it was the court said that it was itself took on the constitutional role of as a guardian of the protection of fundamental rights of Hong Kong residents, and it has the function to review constitutionality of laws made and decisions made by government, in the sense that of considering whether they might contravene the basic law. And in one sense, the scope of that extend to reviewing the constitutionality and lawfulness of decisions made by the Standing Committee of National People's Congress. And of course, that was considered as not proper, and there have been some confusions raised, and which led to the Court of Final Appeal issuing a clarification. The second occasion, 2004, the interpretation was on the rules for changing Hong Kong's legal system, and that is in relation to how Annexes 1 and 2 of the Basic Law should be interpreted, where reference is made to after the year 2007, and under which amendments to, respectively, the election of the chief executive and also the electoral system for the election of legislative council members. The text is such that they only need to be any amendment to the CE's electoral rule will have to be submitted to the Standing Committee for approval, and a change to the election method to LegCo will have to be reported to the Standing Committee for the record. Since this interpretation in 2004, these steps, the steps that are set out in Annexes 1 and 2, are not exhaustive, because on top of what are set out in the two annexes, now there are two additional steps required, and that is for the chief executive to report to the Standing Committee about the need for change, and it is only when the Standing Committee endorses the report of the CE that there should be changes that the proposal for change could then be put to the Legislative Council for a vote. And it is only if 2/3 of the Legislative Council members agree to the proposed change, then followed by the CE giving the consent, then the matter could be sent to the Standing Committee either for approval or for the record. That interpretation, for some critics, had been regarded as having changed the mechanism for change from a 3-step change to a 5-step, a 3-step requirement to a 5-step requirement. That's the interpretation rendered in the year 2004. Following that, we had initially Mr. Tong Kin-hwa. He resigned during his term of office when he was elected to into his second term. A CE's term of office, according to the basic law, is for how long? Do you remember? How long is it? How long is a term of office? The current CE was elected in, that's right. So Carrie Lam was elected into office in 2017, and it's actually 5 years, Stephanie. It's 5 years. So Mrs. Lam's office will expire. We'll have another year or so to run. Right? We'll have another year or so. Mr. Tong resigned. The question then was for how long the person elected to fill the vacancy can be the CE. The law is not exactly clear, so there was an interpretation, and the Standing Committee decided it interpreted as the remainder of the 5 years. There are different ways of looking at it, but the the Standing Committee settled it with the remainder of the 5 years. And as following that, we have, do you remember who was elected to fill that vacancy? Yes, that's Donald Chung. Yes, that's right. So Donald Chung, when he was elected the first time, it was only for the remainder of Mr. Tong's term of office. Then he served another 5 upon expiry because he was successful in the second election. So that dealt with the term of office. Indeed, if you look at the basic law, I said it's not exactly clear how long that is, and let's look at it. Maybe it's easier so that you see. It's Article 46. It says the term of office of the CE shall be 5 years. In fact, it's so clear, right? 5 years is 5 years. He or she may serve for not more than 2 consecutive terms. So itself is fairly neutral, and indeed, the truth of the matter is, although the basic law did envisage, or the drafters, they did envisage that there would be there could be resignation. Indeed, not only resignation. I mean, people die, or for many other reasons that they cannot serve the full term. So and this in a way is simply maybe not considered well enough to cover that scenario in the basic law, a scenario of a CE who could not finish, could not serve the full term. So in a way, it was left open. So an interpretation is called for, and that interpretation, on the face of it, is supplemental, is supplementing the provision. Arguably, it didn't change the meaning of Article 46, but filling in the gap, supplements it, right? It's interesting, whether if there wasn't this mechanism for Standing Committee to interpret the law, whether the matter will be decided, the court in Hong Kong may decide under common law and reach the same result. That case, that situation, or that did not arise, although Chen Wei-yip did take the matter to court, but the interpretation came out before the matter moved on in the judicial proceedings. So it wasn't tested, and it's difficult to speculate what would the court decide if there was not that interpretation. And indeed, it's just a matter of law. If Chen Wei-yip did not withdraw the case and continue with it, the court will have no choice but to follow the Standing Committee's interpretation. So Chen Wei-yip, although he could continue, but that the result will be so obvious that it is quite meaningless. And indeed, if he did go ahead, I suspect that may be considered as an abuse of process and provide a ground for the other parties to strike out the application. We had looked at the Congo case in some detail just now, and it was a case, request that the CFA took the initiative to request the Standing Committee to give an interpretation. The next one, 2016, oath office during Yao Weijing and Sixtus Leung's court case. Well, Yao Weijing and Sixtus Leung, I think for those who are interested in current affairs will probably remember that the way the two took their oath at the Legislative Council chambers in October 2016. I don't know whether you remember that. They made quite a scene, instead of taking the oath of allegiance, or taking the oath by saying they bear allegiance to Hong Kong SAR of PRC, they say they would bear allegiance to Hong Kong nation, and they also mispronounced China, pronounce it in the derogatory manner, and they produce a banner which says Hong Kong is not China, and on those basis, the president of LegCo considered that they had not taken the oath properly in accordance with law, and decided to permit them to retake the oath at the next meeting. The original meeting was on the 12th of October, and then the president of LegCo agreed to allow them to retake the oath. But just the day before this October 19th meeting, the Chief Executive and Secretary for Justice took the matter to court, and complaining that the President's decision was unlawful, and also by the conduct of the two, they should be disqualified from being from assuming the office as a legislator, because they had acted in contravention with the law, and the law being the Oaths and Declarations Ordinance. The matter then went before a judge on the 7th of November. I beg pardon. The matter went before the judge actually on the 18th, right? On the 18th of October, and then the court heard arguments from both sides, and on the 7th of November, well, first of all, the court heard arguments, and then the court said, reserve judgment, I have to go and consider the arguments, and then adjourned. The court did not say when to come back. In fact, it took a bit of time. But during the waiting time, it was on 7th of November, the Standing Committee issued an interpretation of Basic Law Article 104. The interpretation states primarily that oath-taking is the legal prerequisite, is a precondition, required procedure for all the public offices specified in Article 104 to take when they assume office. What are these public offices? These are from the chief executive to the principal officials, members of executive council and of the legislative council, and judges at all levels. They must, in accordance with law, swear to uphold the basic law of Hong Kong, SAR, and swear allegiance to Hong Kong, SAR of the People's Republic of China. So that interpretation actually is a general one. It's not directed against Mr. Yao or Ms. Yao or Mr. Leung, but generally. Now that is one point you should remember. Courts make decisions specifically in respect of parties to the case. Interpretations made by standing committee is made in the general sense. It applies to everyone who comes within the provision. So like this one, it wasn't say, they didn't say Yao Weijing or Leung Zhonghang did it right or correct lawfully or not. No, that wasn't the case. The standing committee was explaining or interpreting the meaning of 104. And it went on to say that they cannot exercise any powers and functions if they did not take the oath in accordance with law, and they will. And also they went on to say they are not entitled to any corresponding entitlement. They cannot enjoy any of that, and also when they take the oath, they must comply with legal requirements, both in form and in content, and must take the oath sincerely and solemnly, and must accurately, completely, and solemnly read out the oath prescribed by law. And then an oath taker is disqualified from assuming the office if the oath taker fails or declines to take the oath. If they intentionally read out words which do not accord with the prescribed wording, or take the oath in a manner which is not sincere or solemn, that will be taken as declining to take the oath. And such an oath taken is invalid, and the oath taker will be disqualified immediately. And also it went on to explain that the person administering the oath has the duty to ensure that the oath is taken in a lawful manner, in compliance with the requirements of the law. So that basically summed up the main points of the interpretation. So the interpretation did not say Yao Weijing or Sixth Leung had lawfully or unlawfully taken oath. No, it is just like passing a law. So that is the interpretation. And remember I mentioned the case went before the court. Interpretation came out as we were waiting for the judge's decision. And at that time, what the public did not know was the judge sent us. Well, I was one of the lawyers representing government, and the judge directed all the lawyers to make further submissions on the effect of the interpretation on the case and also on the judge when deciding the case. We made the point, in response to that direction, we filed our submissions the stance we took was this. Under the common law, the two, Yao and Leung, had not taken the oath lawfully. Secondly, the interpretation and the interpretation was even without the interpretation, we should reach a fair pardon. And then we say according to, if based on the interpretation, we reach the same result. And we say to the court that, but now that the interpretation has been given, the judge or the court is bound by the interpretation, because the interpretation has become part of the law. And it should considered to have taken effect from the 1st of July 1997. Because it was interpretation, so it goes back to the time that it takes effect. Right? We are not saying that this is retrospective, but it is by nature of the interpretation. It must take effect on the very day when the provision under interpretation took effect. This is a common law principle, and the court accepted that. And indeed, you can go to read that first judgment by Mr. Justice Thomas Ngao. Mr. Justice Thomas Ngao he is now the Court of Appeal judge, but at that time he was a Court of First Instance judge. The case went to Court of Appeal. The Court of First Instance decided, agree with the government's stance, and decided that the two decided on two things. First, the president of LegCo was wrong. He could not allow the two to retake the oath, because the first time when they took the oath, it was unlawful, so they were disqualified at that point in time. So once they're disqualified, they will have lost their capacity. They will have lost their capacity as legislator to take an oath. So that's one. And secondly, so the president was wrong to allow them to retake the oath. And secondly, the court confirmed that they were disqualified the moment they took the oath unlawfully or not in accordance with law. They appealed to the Court of Appeal. One of the main point of contention was not about the way the oath was taken, but about the court's role. The court's role in the reviewing or scrutinizing the lawfulness of the president's decision. They argue that the president was making a decision within Legislative Council, and under the common law principle of non-intervention, the court should not take on the matter to scrutinize the lawfulness of the president's decision. That non-intervention principle is this, that because under the common law, the legislature and the judiciary should be independent of each other, especially in matters that relate to the internal operation of Legislative Council. The court should not intervene. That principle was given effect in the 2014 case before the Court of Final Appeal, when the court was deciding on the President's decision to terminate debates on a bill back in May 2012. That was the time when some Legislative Council members filibuster the proceedings of LegCo. Filibuster is libel. They kept on making speeches, long speeches, and trying to delay the process. The President at the time decided not to allow it to happen, to continue to happen, and discontinue the debate. The case went to court, and the court decided that it should not intervene because the President of Legislative Council was exercising his power in accordance with the Basic Law, and that power should give the President sufficient discretion to decide when to terminate a debate. And of course, they recognize, or they, on the basis that he should be acting, he has a duty to ensure that the proceedings are being conducted in an orderly, effective, and fair manner. So that was what the doctrine of non-intervention is about. When it comes back to when examining the oath-taking requirement, the Court of Appeal, by the time the case went to the Court of Appeal, there wasn't really much room for the Court of Appeal to decide, to make a new decision, because by that time the Standing Committee's interpretation has already been issued. So the Court of Appeal must follow the interpretation. Although the appellants argue that the interpretation issued by the Standing Committee did not qualify as an interpretation, but it was an amendment of the Basic Law, introducing new matters into the law. The Court of Appeal took the attitude that lawyers in Hong Kong who are not trained in Chinese law was not competent enough to make those comments or to argue or to take all those points in their argument, and reminded everybody that the interpretation was an act of the Standing Committee being exercised in another system, in the mainland legal system, which has legal effect in Hong Kong. So that is a very significant point made by the CA, made by the Court of Appeal. The case went on to Court of Sixtus Leung and Yao Wei-ching did not succeed in overturning the decision of the first instance judge, and they then went on to appealing to the Court of Final Appeal. For appealing to Court of Final Appeal, they need permission from the CA, from the Court of Appeal, which they failed to get. So they went to the Appeal Committee of the Court of Final Appeal. Appeal Committee of the Court of Final Appeal comprises 3 judges instead of 5. An appellant to CFA has to convince the Appeal Committee, the panel of 3 judges, that the case involves a general public importance. and unless and of course the appeal committee will give it an initial examination and see whether the case is reasonably arguable. If the case is not reasonably arguable, i.e. no chance of success, leave will not be given. That was the result. The committee took the view that the chances of success would not be reasonable, and they dismissed the application and uphold the decisions of the Court of Appeal and the Court of Final Appeal. And indeed, it's worth, actually, if you're really interested, you should go to looking at the judgment or the determination rendered by the appeal committee. The three judges took the opportunity to review the constitutional framework of the Hong Kong Special Administrative Region and also put the basic law in its proper place, and also clarify again the constitutional relationship between Hong Kong as the Special Administrative Region and the central authorities, emphasizing again that the constitutional framework, within the constitutional framework of Hong Kong SAR, the basic law is a national law of the PRC, enacted by the MPC pursuant to Article 31 of the Constitution, and the Standing Committee's power to interpret the basic law actually reflects what is contained in Article 67(4) of the PRC Constitution. And that power embraces all national laws. And that interpretation is conducted under a different system of law to the common law system in force in Hong Kong. And that interpretation can clarify the law or supplement the law. And once an interpretation is issued by the Standing Committee, it is binding on the course of Hong Kong SAR. And once it's declared what the law is, then it also says the effect of declaring what the law has always been since the coming into effect of the basic law on 1st of July 1997. So that is an occasion when the Standing Committee issue an interpretation in the middle of a case. It was from a legal perspective, that was within the power of the Standing Committee to have taken that course of action. Whether it was a proper, a wise move at all, is another matter. It is something that different commentators have expressed or had expressed different views on it. I don't know what your thinking is, but it was a fact, and as a lawyer, you really have to you really have no choice but to accept it. Yeah. Okay. So, any questions on these? Good. You will see, probably for those you probably already noticed that I have been staying on this PPT without going to the next 2 or 3, but indeed what I've been saying is briefly actually the main points can be found here, right? So no court case in China. Most interpretations made when there are no court cases, and only one similar interpretation in Hong Kong so far. And 204, there was a standing committee interpret Annex 1 and 2. I mentioned that. It wasn't requested by anyone in Hong Kong, and there was this 5-stage process for universal suffrage, right? Before court case, that was about term of office, and so the case did not go ahead because no point, the court dismissed that. Remember that? And then during the case, that was the Congo case, before Court of Final Appeal decided to make the final decision. And then the next one was about the electoral oath case. And on the oath case, it wasn't an invitation by the court, nor was it by anyone else. The standing committee took the initiative to render the interpretation. After the court case, of course, we have Ngarling. Ngarling. Ngarling is this one, of course, is typically is a case which I think demonstrates best demonstrate the differences between Chinese and common law system of interpretation. When Court of Final Appeal kept emphasizing that it's purposive approach, but at the same time, the meaning must be within those meanings that the language used in the law can bear. You can't give meaning to words that the words cannot bear, i.e., you can't bend the meaning. You can just pick a meaning from somewhere and say round means square. Yeah. So emphasis. Remember the PPTs that I showed you. The emphasis still is coming back to the words used. Whereas under the Chinese system, is the theory is just like raised by earlier Jia Yi about the best interpreter would be the lawmaker, because only they will know best what the intention was when making the law. And interpretation is to better reveal the intention of the law of the lawmakers and to give effect to them. That's all sound very well, but such approach may not sustain, because the lawmakers may change and they may die, they may change term. So that is simply unrealistic. But that's the fundamental principle. Although nowadays in modern interpretation by PRC, I think they are getting closer and closer to the principle adopted by common law courts, but in a different capacity, either as a lawmaker or there are other systems of interpretation, like interpretation rendered by the Supreme People's Court or by the Supreme Proctorate, the 检察院. Just a review of what we had looked at right about, and here the Court of Final Appeal did also express as a matter of principle that if the interpretation concern provisions that protects the fundamental rights of citizens, then the court should adopt a generous approach, i.e., to make it easier, or make the protection more effective, to decide in favor of the citizen, to their advantage. Thus, in a way, is consistent with the whole concept of having such provisions in the constitutional document. Because in the sort of Western democracy mindset, a constitution is for limiting the power of government and for ensuring that people's rights are properly safeguarded against those who are given the authority to exercise public powers. So that is the underlying philosophy in common law democracies. So that's why the right to vote issue, the court was fairly straightforward, don't they? And especially in Zhang Fengyun, where the court has said it's so clear, there's no room for interpretation. Of course, on that one, the standing committee did not respond with another interpretation. But in the case of Article 24.2.3, there government took the matter to standing committee because they thought under if the decision of Ngarling has to be given full effect, the SAR, the Special Administrative Region, will be faced with a problem of having a very large number of descendants who are qualified, who will be qualified to becoming Hong Kong permanent resident. Here it's just more than 1 million. Actually, at the time, it was said that there would be 1.76 million, a very large number based on some statistical analysis. Right. The next few slides is actually, what I had just said in explaining Ngarling and explaining the different concepts of interpretation. So I don't propose to go through these, but the critical issue here is you will see they generated a lot of controversies at the time, and also indeed it really depends on how you look at it, different perspectives, and they come to different answers and different conclusions, and so often, so easily been classified as a political decision. I mean, the interpretation is political, but I should remind ourselves that indeed, yes, standing committee is a political body. Is the body, is the executive arm of the supreme organ of power in China. But when it comes to interpretation, do not forget that is an interpretation done in a different system, a system different to Hong Kong's, and that they apply different principles. And it's just is not inconceivable that they may reach a different conclusion. So that's all I wanted to say about interpretation and how that operates in the two different systems, and how at the end of the day, how in the course of it we cannot avoid seeing difference in conclusions, the sort of frictions that have been caused, but ultimately, under the system as defined by the Basic Law, it will have to be the interpretation of the Standing Committee that will prevail, that will trump other decisions. Right. Any questions? Do we have any questions? Well, for those who have a copy of my PPTs, you will know that I have basically come to the end of chapter 7. Yeah, I've basically come to the end of chapter 7, and it was my original sequence is where we come to a stage where we'll do a sort of a review of what we had learned and how you should focus in your studies. But of course, we have dealt with this part before we started with chapter 8 on human rights. What I would like to do is to give you 10 minutes to quickly review what you have on hand and see if you might have any question to ask me at this moment. And I'll return after this break, and then I will look at the last part of chapter 8, which I did not cover, and it was 8.4 over Article 23 national security legislation as a topic. But I shall use not much time, but just a little bit of time to cover what's in the menu, and also a very brief introduction to the law on safeguarding national security in Hong Kong SAR, the law that came into effect on June 30th, 2020. All right, so let's come back in 10 minutes, and please do look at the things that you have on hand, and if you have any questions, you can raise them when we come back. All right, thank you. Right. Are there any questions? Okay. Now, 8.4 of the manual has the topic as a heading is Article 23 National Security Legislation. It's under Basic Law Article 23. Hong Kong is required to enact on its own. On its own is quoted from the Basic Law, laws covering the following national security offences. And these are treason, secession, subversion against the Central People's Government, sedition, theft of state secrets, political activities by foreign political organizations, and links between local and foreign political organizations. Under the common law, it's been said many times that it's unclear what subversion actually means, and it was in the process of government explaining the bill to give effect to Article 23 back in the year 2003 that it was elaborated to mean undermining the socialist system of government established under the PRC Constitution 1982. Of course, when we were looking at the meaning of capitalistic system and Article 5 of the Basic Law, where it was said clearly that a socialist system will not be practiced in Hong Kong, we did also consider what actually it means in law. It is a concept which itself is difficult for a legal definition. Be that as it may, those are the 7 areas which Hong Kong has a constitutional to make law. And when the common law, when the basic law took effect, 1st of July 1997, actually the following ordinances contain offences or cover most of the 7 types of offences, national security offences, and these are in existing law: the treason, sedition, theft of state secrets or political activities by foreign political organizations, or links between local and foreign political organizations. These are contained in the various chapters. But one thing that was a bit of a difficulty was the offences, especially the offences of treason and sedition, are based on very archaic language, and indeed the offences as defined in the ordinance may not survive a human rights complaint, a challenge. So a court may not consider that as effective law, right? And this is all because if before 97 is because of Hong Kong Bill of Rights Ordinance, and then after 97, Article 39 and also Hong Kong Bill of Rights Ordinance may provide a basis for their challenge, for challenging their legality, right? So it's sort of taken a long time for Hong Kong SAR government to enact the required law. Attempt was tried in 2003, as you can see, second last paragraph here. However, the bill was abandoned because it was unpopular at the time, and it has since been only a commitment, on the part of Hong Kong government, but without a specific timetable. And this last paragraph in the manual, you must, this is important for you in the overall scheme of protecting human rights. And for that to apply, i.e. Article 39 of the Basic Law to apply to national security legislation, this legislation has to comply with the same rules that also apply to all other restrictions on human rights. This includes complying with the proportionality test that, among other things, assesses whether any restrictions on rights meet the minimum impairment test and are no more than necessary for the legitimate purpose of protecting national security. For those who are more interested in the finding out or in deciding how best to deal with the assignment, this is a paragraph that will help you to focus on the second part of Article 39, how the courts have developed the different tests in order to better to give effect to Article 39 and therefore the provisions in the International Covenant on Civil and Political Rights. And then came last year, 2020, May 2020, the National People's Congress made a decision tasking the Standing Committee to enact laws for taking effect in Hong Kong SAR for safeguarding national security. The justification or the reason being that it had taken too long for Hong Kong to enact the national security laws as required under Article 23, and secondly, the social unrest that happened from June 2019 until sort of mid 2020 was considered that one of the reasons was that there was a lack of legislation on national security. So the Standing Committee took on this task, and they went ahead and drafted the law, and the law was given the name the Law of the People's Republic of China on Safeguarding the National Security in Hong Kong Special Administrative Region. Excuse me. Can you see that? Can you see what I'm sharing with you now? So in June, or rather June 30th, the Standing Committee passed this law. Now, the question I want to put to you is, does this law can this law apply to Hong Kong directly, immediately, following the Standing Committee's passage of this law? Can that happen? No. Why? And what has to be done in order to make that happen? Yeah, that is before that, Jia, before that, the law has to be included in Annex 3 of the Basic Law. This is in accordance with Article 18. Right? And once that's done, according to Article 18, is either CE's promulgation or enactment of that national law into local law. On this particular piece of law, CE did it by way of promulgation. And you remember it was promulgated on the 30th of June, and for it to start taking effect 11 p.m. on that day. Right. What I wanted to show you, wanted you to see is this, that this is a piece of national law, but the structure follows that of typical mainland law. It's got a Chapter 1 General Principles, 总则, and then the various headings, various topics. And one thing that has been that was raised as a query was whether fundamental human rights will be damaged or impinged. And the official answer response has always been that Article 4, where it says human rights shall be respected and protected in safeguarding national security in the Hong Kong Special Administrative Region, and so on. And then it goes on to say the rights and freedoms, including the freedoms of speech, of the press, publication, association, and so on and so forth, enjoyed under the Basic Law, and the provisions of the ICCPR shall be protected in accordance with the law. And it then goes on to say the principle of the rule of law shall be adhered to in preventing, suppressing, imposing punishment, and the person committed of the act that constitute offense shall be convicted and punished in accordance with law, and no one shall be convicted or punished for acts that does not constitute an offense. And a person is presumed innocent until convicted by a judicial body, and the right to defend in judicial proceedings they are entitled to under the law, and no one shall be liable to be tried or punished until he or she has been finally convicted or acquitted. So the official response to that, to the worry, is that it's all set out in the law that the protection will continue. Protection given under the Basic Law will be the same here under this law. There are actually one other feature I want to show you, and that is the relationship between this law and the Hong Kong laws. And the provision is that this law prevails over Hong Kong law. So this is under one country, two systems, and which is fine. This is it comes into Hong Kong, as it were, through Annex 3 and promulgation. But under the Basic Law, one would have thought that it is only the Basic Law that can trump local law. But now, in addition to that, Article 62 says this law shall prevail where provisions of the local laws of Hong Kong SAR are inconsistent with this law. So this is something which had raised some eyebrows, and people had raised concern. The other is Article 65. It's about interpretation. The power of interpretation of this law shall be vested in standing committee. Now, this one on its own it's nothing new. Of course, it's nothing new. We know under Constitution, power of interpretation lies with standing committee. But because it has the status over and above Hong Kong law, so in that sense, and without much experience of how it operates, it has raised some concern. And you should also notice this is something which I think the mainland authority had been if you like, aware of this issue of applying Chinese law, mainland law, directly in Hong Kong. And that's why when you look at Article 64, it has done some textual adaptation. Now, this is because of the two different systems, where on the mainland, in the mainland legal system, there are terminologies that are strange to Hong Kong. I mean, we don't know what is short-term detention and so on. And so this is a section which does the textual conversion. All right. So those are the main points I wanted to just remind you. The national security law is a very important piece of legislation, not because of the subject matter, not only because of the subject matter, but also because in the context of learning the basic law and understanding how one country to system operates and the ground rules as set by the basic law, whether the national security law actually has brought in changes to this fundamental feature. All right. So, are there any questions? I saw that somebody said I cannot hear something. I don't know what that means. I cannot hear something. But you have any questions? Please raise your hand. I'll turn on your microphone for you to say it, or you wanted to type it in. Please do so. It's interesting. I doubt if the Hong Kong courts have jurisdiction over the legality of the national security law. But at the same time, the national security law does say that everything else, whatever done, has to comply with ICCPR and so on. So it's just a matter of wording, I think. But in practice, the court will not be looking at the law itself, but looking at what we call operational review. In fact, in human rights law, I mean, I'm not trying to make it too complicated, but without reviewing the law itself, it can actually review the actions undertaken under that law. I mean, in the emergency regulations ordinance case that I did, the anti-mask law case, the court did not consider the emergency regulations ordinance as problematic. But when it goes to looking at the subsidiary legislation, the regulation that give effect to the anti-mask prohibition, the court make it very clear that these laws are subject to the court's human rights scrutiny. I think the same logic should apply, or could apply. Well, this is another interesting point. Courts, they of course, it's not a matter of right, but it's a necessity, isn't it? When they deal with NSL cases, they have to give it some meaning. So this comes to the very interesting conceptual limitation. I mean, even on the mainland, judges on the mainland cannot interpret the law, but judges only apply the law. But that's not the entire story. The story should be this: judges do not interpret the law, but they apply the law according to what they understand the law is. So when you say that they have no right or no power to interpret law, it's a necessity that when applying the law, they have to give the law some meaning. So I think this the point itself doesn't really involve any practical difficulty, but as a matter of legal theory, that is something that has to be clarified. Are we all right? Good. Thank you so much. We will meet again 1st of April. Well, of course, I'll be seeing your work before then, and you have got your assignment to write, and so best of luck. And in the meantime, there's the Chinese New Year coming up. I think it's what, mid-February, February 12th. So I hope you have a nice break then. So any questions before we go, or before I go? Okay, thank you so much.